Women in marriage are not the properties of their husbands. Domestic violence is still not taken that seriously unless there is physical violence. Then domestic violence in terms of verbal abuse, sexual abuse, financial abuse is never taken seriously. It is seen as just something that the woman has to tolerate, and it's part of marriage, part of family life. The issue of gender identity was still extremely unknown. Courts, judges, lawyers didn't know how to respond to it. As lawyers, we were learning with our clients. My learning with transgender rights was, in fact, expanded my understanding of gender equality. I mean, they changed me. Gender is not dependent on what your body is. Gender is not dependent on what surgery or medical reassignment can do, but gender identity is how you feel.
25 years, hundreds of cases, one mission, the power of law to bring change. In this episode of Expressions, we have Supreme Court litigator and founder of the Center for Law and Policy Research, Jayana Kothari, taking us through the battles that rewrote India's law on marital rape, disability rights, and transgender equality. Stay with us.
Hi, welcome to Expressions. I'm Neha. Today I'm joined by Jayana Kothari, a very powerful woman, very strong woman, and let's get to know about her journey and how she's contributed meaningfully to the society. Hi, Jayana. Thank you, and what an incredible journey. I read about you in the last few days. So you've spent about 25 years fighting over other people's rights. What has that journey cost you?
Thanks for having me, Neha.
Thank you.
No, the journey has not cost me. In fact, it's just been so enriching. I mean, that's all I can say. My work, my litigation, representing people, representing women, people with disabilities, representing really people from vulnerable communities who don't have access to justice, and the opportunity to take up a lot of human rights constitutional cases has only made me realize the power of the law, the power of our courts in bringing about change, meaningful change, the power of our constitution, and really the opportunity to fight for people who are really fighting against great odds, and to be part of their struggle.
Yeah.
So that's been the most enriching part.
Yeah. I mean, you say the power of court, it truly helps. And, you're saying it's a positive impact on these people, that they actually make a difference with.
Yeah, I mean, maybe sometimes people from the outside feel that, do courts really, are they, we have long court battles, do they result in anything? That is sometimes a common perception, but, when you are individual stories, when you are fighting for your rights, fighting against injustice, whatever it may be the opportunity to get a government job, it could be to get child custody, it could be to get compensation. The legal battle is sometimes long,
Yeah.
but if fought well, if we see results, we do see results, and a lot of our big landmark decisions have led to big social change. When you see the decriminalization of 377, it was a change that the LGBTQ community had been fighting for 25 years. We needed that court decision to decriminalize it. So we've seen, and those are big changes, but in individual cases as well. People who have fought through right up to the Supreme Court, ultimately, getting the relief in some way what they want. It's a vindication of their struggle as well.
Nice. So you could have been a corporate lawyer earning 10 times more, but so why did you choose the harder road, and what made you choose this?
Yeah. No, it wasn't really a choice of choosing a harder or an easier route. When I graduated and I did my master's, I did know for a fact that I wanted to litigate. I wanted to be in court. And so doing, as a litigating counsel was the natural course for me. I really didn't have to make a choice of not selecting a corporate law career. And when I decided to do litigation, I really wanted to be in India and to litigate, among other things, for people who could not afford legal help. So that was one of my areas of interest and my focus. I had during college been involved in a lot of social movements, and so I had seen what not having access to law can do. So I was very keen to do that. So for me, it was just something that was something I was very sure I wanted to do. So when I finished my master's and I came back, that was the time where I had to decide where I wanted to practice. And so I went to Delhi. I wanted to practice in the Supreme Court, and I had the opportunity of practicing and working under Indira Jaisingh, one of our foremost human rights, feminist lawyers. And I so therefore worked with her for some time, where she took up a lot of labor rights cases, gender equality cases, public interest law work. And then after some time, I came to Bangalore and I said, okay, well, I need to, Bangalore is where my family's based. I need to start my litigation career here. So I came back here and I joined a big litigation firm here, Holla and Holla, which was excellent because it gave me a wide exposure to a wide range of cases, from government cases to regular property matters to, service matters to everything. So I did that for a while in the Karnataka High Court, where I could really get familiar with the High Court. And then after about 2 years of working with them, I said, okay, now I want to start my own practice so that I can do the kind of work that I wanted to do. And so then I started my own practice in Bangalore. And I just got married, so I wanted to settle down. And then I realized that, because I had built a lot of networks with civil society groups, NGOs, because I was always involved with them, engaged with them, I started getting not just, of course, regular matters from different people, but also a lot of human rights work, a lot of constitutional law work, a lot of public interest work.
Yeah.
And so I continued that. That has always been work that I had continued. And so, yeah, just continued my work here over the last 25 years.
Amazing. Is there a case you lost that still keeps you up at night?
Yeah. So there's one case which I won, but I lost. You can say that, and this has been a very important case. This was a case of a person who was a KS officer in Karnataka, a person with disability, and we started his challenge, his legal challenge from Bangalore, from Karnataka, seeking reservation in promotions for persons with disabilities. Now, the law, the Rights of Persons with Disabilities Act and the previous legislation provided for reservations in employment for people with disabilities. But the unique thing in his case was that, yes, he was a person with disabilities, but what about promotions? And there was no reservation implemented. And so he wanted, so when the promotion from KAS to IAS officers was happening, he was deprived of the opportunity. And so then we fought for that. That went from the administrative tribunal to the High Court and then ultimately to the Supreme Court. The Supreme Court in 2020 gave the decision in his favor. And mind you, this is a challenge from 2014. His promotion was due in 2014. In 2020, we got a favorable decision from the Supreme Court, which actually laid down the law, which held that persons with disabilities do have reservations in promotions as well. Because, employment is not just when you get in, right? Employment means your entire work life and includes all your promotions. And if you are not given equal opportunity as a person with disabilities in promotions, then how do you get ahead? And finally, the court held that, yes, he should be given the promotion. But unfortunately, even after getting the favorable verdict, the government didn't implement it. Then we had to file a contempt petition. The contempt petition is still pending. And in the meanwhile, he retired. And we did inform the court that, well, he's retiring. And unless he's given his promotion, his entire fight would be for nothing, right? But unfortunately, his promotion didn't happen. The case is still going on. Now, after retirement, the government has passed an order for his retrospective promotion, but obviously he can't take it up. It will just be on paper. So the case is still pending, but yes, that is something that I think about, because he's been someone who has been so diligent and has fought for it from all these, for more than 10 years. He got it, but despite getting a judgment, he didn't get the fruits of it. So I do think about cases like these.
People describe two kinds of leader under pressure: the lighthouse, calm, at the center of the storm, and the alchemist who turns the storm into fuel. So, which one are you in the courtroom and at home?
So I'm, in the courtroom, I'm the calm lighthouse, able to manage whatever is thrown at me and all the uncertainties in court and the drama of court. I'm able to totally manage that with the exterior calmness. Of course, there are all kinds of things happening inside, but at home and at my office, I'm the opposite, where I turn, it's literally like a storm that I use to fuel the work. So yeah, I can be quite a storm in the office and at home when I know that I have, something difficult to prep for. But in court, I can keep my calm, and that's, I guess, my strength.
Yeah. You stood before India's highest court and argued that a wife is not her husband's property. What was going through your mind at that time? And can you take us through that?
So this was the challenge to the adultery provision in the Supreme Court, I think in 2018, that the arguments were held. What was going through really in my mind was that, do we really need to argue this? I mean, is this, we have such an outdated legislative provision, which is still on the statute books, where a man can file a complaint for adultery against another man for being with his wife, meaning that his wife was his property and she could not have relations with anyone else. And we are at a stage where we are still having to argue that women in marriage are not the properties of their husbands. And that needed argument. And that was what was shocking. I mean, internally, of course, we needed to make those arguments constitutionally to set aside that legislative provision. But that was what I was thinking. And while the bench, of course, ruled favorably, it was still, it made me think of, so many of the kind of divorce cases and domestic violence cases that I've taken up, where the core issue is that you're arguing in court that I have a right to not be treated unequally, to be treated as a full human being in marriage. And marriage doesn't mean that the wife becomes the property of the husband or that he has any rights over her.
Yeah.
But that basic principle still needs to be argued today in our society, in our courts. And I guess that is something we still have to contend with.
But there's no improvement in your 25 years in that ideology?
There is minor improvement, I would say. Yes, we've had, sections of the criminal law like adultery been decriminalized. So yes, we've had progress. We have a law prohibiting domestic violence, and we do get good orders from courts. But still, domestic violence is still not taken that seriously unless there is physical violence, So where there is physical violence and evidence of that, yes, it's taken seriously by the courts, by police, by families, by society. But if there is no physical violence, then domestic violence in terms of verbal abuse, sexual abuse, financial abuse is never taken seriously. It is seen as just something that the woman has to tolerate, and it's part of marriage, part of family life. And
I read somewhere that many states usually in such cases favor women more. Is that true?
Well, we do have, I wouldn't say favor women more or less, because the law on domestic violence it is gender specific. it is only for women because there has been an empirical evidence of the fact that women face domestic violence to a much larger degree, and therefore our law is focused on women. So I guess if the in the facts of a particular case, if the law is applied and if there is domestic violence made out, then it's not really about favoring the woman; it's about applying the law.
Yeah.
And that's what courts should do.
Yeah. I'm just wondering how the opposing advocate and the lawyers agreed to take up this thing where the guy said that, she's my property.
Yeah. Well, it's of course put in a legal way, denying that these things happened or that she provoked it or that it didn't happen in the manner in which it is stated to have happened.
You said just now also when we were talking that the law will always take its time. So what do you say to a woman who simply cannot wait for justice?
Yeah, I mean, there are some cases where which are extremely time sensitive and where unfortunately the entire legal process in its normal course cannot be applied, and therefore you need immediate relief. Courts have to step in, give immediate protection orders if that is the case. In so many cases we see where it concerns children, concerns issues of violence, there the courts have to step in immediately, and we do have provisions for that. So, well, the entire case may take time, but can we ensure that immediate protection is given where immediate relief is needed?
Yeah. And even recently, there were some videos of Harish Salve mentioning that how children suffer due to the delay in the orders being given. So that's quite sad, I feel. What is one law still in force today that would shock every woman watching this?
One law still in force, which maybe people don't know about, and perhaps that is shocking, or I don't know if it's shocking enough, is the right, the restitution of conjugal rights. We have a law within our family laws that which is termed as restitution of conjugal rights. It sounds like a very outdated legal term, but it means really the right for any spouse to go to court and say, I have the right to be with my spouse, and my spouse should therefore be directed to come and join me. Now, this is, it seems harmless enough, but it is used specifically by men against women, especially when they file for divorce. When women are facing domestic violence and they seek to leave abusive relationships, that's when men, as a counterblast, I mean, I'm just using it not in all cases, but what you largely see in evidence, it's used to say that I want, petition for restitution of conjugal rights is filed saying that I want my spouse to resume the marital relationship with me. Now, of course, both parties can use it, but it is used predominantly against women. And women have to actually prove and say that I don't want to be with my spouse. And, this is premised against the basic constitutional principles of the right to bodily autonomy, the right to privacy, the right to decide who you want to be with, where you want to live. As an adult, can you today be forced to say that you have to live with someone, even if that person is your spouse? That goes against those very principles. But we still have, that law is being challenged. It's pending challenge, but it is still on the statute books and cases are being filed every day.
Are you doing something about it?
Well, there is a petition filed and hopefully let's see what happens.
Okay. So you've stood beside people this country often refused to see. Which client or case changed you personally?
I feel it's not one or two clients or cases, but it's been a large number of them. I feel that many of my early cases on representing trans persons, on transgender rights have been have been a big learning experience, especially because the issue, the taking up the issue in court itself many years ago. Now, many cases have been, taken up before the courts. But in the early days, maybe about 7 or 8 years ago, when we started taking up on the first cases on transgender rights in the High Courts and the Supreme Court, the issue of gender identity was still extremely unknown. Courts, judges, lawyers didn't know how to respond to it. As lawyers, we were learning with our clients what their issues were. And while I've always been working on gender equality, my learning with transgender rights was, in fact, expanded my understanding of gender equality. And so, therefore, to be able to, so those cases were really, really, they changed me, because it really made me understand that ultimately, what the message or what the campaign of the trans rights movement is, that, gender is how you feel. Gender is not dependent on what your body is. Gender is not dependent on what surgery or medical reassignment can do, but gender identity is how you feel, right? And that you argue it in court, but then you go back home and think about it, right? And that's the kind of learning and enrichment you get from taking up some of these cases. And I think some of my early cases that really changed me were some of my disability rights cases. Representing people with disabilities in court, and really fighting for basic requirements of equal opportunity in employment, that some of the it seems at the presently so simple, but the biggest battles were, my early cases were where the government would, put out notifications for government employment, like teachers, and they would exclude people with visual disabilities, people who are blind. And the basic questions was that, how can they teach? And we had to answer that, why don't you get some qualified teachers who are blind and put them in a classroom and see how they teach. But the basic thinking that people with disabilities would not be able to do the work, and dispelling that notion.
Without even looking into it. Yeah.
Really looking into it. And then, really, when you have to deal with that, you really realize that, do we also have biases, that we think that certain people are capable and certain people are not capable, and why do we have those biases, and kind of challenging that internally. So I think some of these cases, doing these cases over these years, has, I think, really taught me to question my own internal biases and trying to address that.
Talking about disabilities, you've helped more than 300 government jobs, job categories for persons with disabilities. Take us through the big breakthrough and the journey, and what was that like?
Yeah, so this has been actually a journey of about the last 10, 12 years. The early cases were like this. The early cases were just an attempt to get a foot in the door, because the government would, call for appointments to government jobs, and very low-level government jobs, entry-level government jobs, as assistants, as music teachers, or as peons, primary school teachers. And even those jobs would have a complete bar on people with disabilities, despite having the previous legislation which mandated reservations. So all of those cases I challenged, representing people with disabilities. And every challenge led to the understanding that the government had exempted those jobs. The law provided an exemption if a particular category of disability was not able, a person with disability was not able to do the job. So we questioned that. And then finally, after several years, I think about 7 or 8 years of challenging government notifications every year, we finally asked the High Court that the central government has a list of identified posts. In the central government, if you can do these jobs, for example, being a judge in a magistrate's court or in the High Court. Do we have judges with disabilities? We don't, right? Because though positions of judges have been identified as being capable for people with disabilities, they were never appointed. So we said, why do we have to do that exercise again? If in the central government they are considered to be capable, then why should the state government take a different position? And so then what the High Court did is that, and asked the state government, just adopt the central government list. And therefore, the entire central government list of jobs was adopted to apply to equivalent jobs in the Karnataka High Court, and therefore it led to a whole additional range of jobs that could be identified for persons with disabilities and, of course, reserved. I mean, that led to a lot more positions, but I still have the basic flaw in the legislation is that you still need to identify a job for a person with disabilities instead of assuming that all jobs can be done by everyone. And where someone has a disability, you provide them reasonable accommodation. But we have the law that we have.
Your study of Karnataka's fast-track courts was titled The Myth of Speedy and Substantive Justice. What did your research reveal? Are these courts failing survivors of sexual assault and child abuse?
So we did this study immediately after the fast-track courts were set up, after the whole amendments, criminal law amendments after the Nirbhaya case. So in 2013, after the Nirbhaya case and the protests and the changes in the law, there were fast-track courts set up everywhere for sexual assault cases. And I think this report was in 2015. We studied all the cases for an entire year that were instituted in the fast-track courts to see two things. One is whether the courts were fast and whether the courts, since they were special courts only for sexual assault cases, were they better in the sense, were they giving substantive justice? Were they able to deal with those cases better? Because that was the point of these special fast-track courts. Our research actually showed that it was not necessarily so. They were not necessarily faster. In fact, they were not faster in disposing cases than regular courts, regular criminal courts. So they were not faster. They were disposing cases at the same rate and sometimes even slower. Secondly, when you say better, were they better at dispensing justice? That can only be assessed in the conviction rate, right? Are they leading to more convictions? And that was also not the case. So even the conviction rates in cases of sexual assault, both for adults and for child sexual assault cases, was not necessarily higher. And so, therefore, we question that how effective are these special fast-track courts? And one of the things we saw is that the main reason why the cases led to acquittals is due to witnesses turning hostile. Witnesses turn hostile because of the threats they face, the harassment from different parties, from the accused, all of that, and due to which witnesses turn hostile. And for that, you need victim protection measures, you need witness protection measures to be, put in place by the courts and the police. And secondly, courts were still using outdated forms of evidence like the two-finger test, which, the Supreme Court has repeatedly held that should not be used. Medical evidence and, evidence of the woman's past sexual history was still being relied on in evidence which should not be used. So what we recommended is that if you really want to have special fast-track courts, the courts and the entire system needs training. You need a law for special fast-track courts which would mandate that there are special judges appointed who get training on sexual assault cases. There are special prosecutors who are appointed who have training on sexual assault cases and the law around it. You have witness protection measures, and then you have a special fast-track, or not to just have it. And then, nobody knows how different it is. It serves no purpose.
Last one, if you could write one new law tonight and India woke up to it tomorrow morning, what would it be?
Yeah, I thought about that question, and my answer to that would be to remove the exception to marital rape. We are, that challenge is pending in court, but it's been legislation that needs to have come many, many years ago. We still have it. We have an exception to marital rape where rape is not rape if it is within marriage, and that needs to go. And that needs to go soon.
Thank you very much for this enlightening conversation. I really had a good time. Thank you.
Thanks for having me.
Today, Jayna taught us that winning a case and winning justice are two different things. If this episode of Expressions moved you, don't forget to like, share and subscribe to the New Indian Express. Until we see you next time.